Okay, so mediation as response to the challenges of this pandemic. So let me share with you what mediation is, no, and give you a brief background on what mediation is all about. In the year 2004, we had our Alternative Dispute Resolution Law, otherwise called RA 9285. We refer to these as the ADR Law of 2004. No, what is alternative dispute resolution? Now, if you notice that word alternate, there is that word alternative. The default behavior of people normally, if there are disputes or if people feel that they have been that their rights have been violated, no, the default behavior is to go to courts. Diba? Sinasabi natin, magkita na lang tayo sa korte, magkita na lang tayo sa korte. No? But little did we know that there are other modes of resolving conflicts. So briefly, let me tell you that this ADR law of 2004 provides for mediation, among other mechanisms or modes of resolution. No, it also covers international commercial arbitration and even covers construction industry arbitration. We have also incorporated in our law the ADR law of 2004, the 1985 ancestral law model covering international commercial arbitration, and the 1958 New York Convention, where the Philippines was one of the signatories. Now, the intention of the ADR law is to help declog our court dockets. As you know, there are a lot of cases pending in our regular courts. So that we came up with this law of 2004 to enable parties to resolve their disputes without going to courts. So if I may show you this, no? Can everybody see this? And can everybody appreciate the colors here? Okay, these are just the basic modes of conflict resolution. There are hybrids and there are other forms of conflict resolution. And as you know, just like all other things, ADR also evolves. That is why we have hybrids. But these are just the modes of resolution. So one form in conflict resolution is negotiation. Negotiation happens between two persons. No, there is no third party neutral here. Here, parties sit down, exchange ideas until such time that they have an agreement, no, that will be mutually beneficial to both parties. In conciliation, parties are there, but there is a third party neutral who tries to conciliate the parties. Same thing in mediation. However, the difference is that in conciliation, the third party offers legal advice, opinions, so on and so forth, to help the parties, no, reach an amicable settlement. However, in mediation, the third party neutral has control of the process, but it is actually the parties who really try to settle their differences. Why do we opt for that? We think that it is the parties who know best, know what the solution to their problem is. So the mediator here tries to help the parties find different options, understand the conflict, find different options, and finally choose which option is the best to address their concern and solve their conflict. Now, arbitration, some of you may have heard about arbitration. This is more akin to litigation. This is closest to litigation. Here, the third party neutral renders a decision. No, may decision po. Nagsasabi ng isang panalo, isa ang hindi. However, arbitration, is apart from the judicial system. So that negotiation, conciliation, mediation, and arbitration are not part of our judicial system. There is such a thing as private ADR. Okay, and of course, you see this litigation. It's at the end of the other conflict spectrum. Now, more often than not, when people are aggrieved, they always say, I'll see you in court. You will see my lawyer. Talk to my lawyer. That is what we call litigation. Okay. Now, these are the ways we try to resolve conflict. If you notice here in the spectrum, there is no litigation anymore. So when we remove litigation, this leaves us with the ADR resolution spectrum. Okay, so let me tell you about the National Center for Mediation, and you'll be very happy that the office of the NCM is at PCCI building, right? Because the National Center for Mediation is a brainchild of the Philippine Chamber of Commerce, or PCCI. Considered to be, of course, a one voice of the Philippine industry. Now, this was established in November 23 of 2007, just 3 years after the enactment of RA 9285. And this is envisioned to assist in settling commercial disputes. You know that there are 7 to 8 convener groups in PCCI. And since everyone in PCCI is engaged in business, the people have foreseen that there may be commercial disputes. And so to assist these convener groups, NCM was created and put up to address the business conflicts within PCCI. Now, what are the features basically of mediation? There is party autonomy. What is party autonomy? Mediation is a consensual process. If both parties agree to bring your dispute to mediation, pwede po natin gawin yan. And the parties can choose their mediator. We have a roster of accredited mediators, accredited by the DOJ, Department of Justice, Office of Alternative Dispute Resolution, as well as other accreditation entities. And you can choose your mediator from our roster. Unlike when you bring a case in court, you cannot choose your judge. You cannot even trifle with the ruffling of the case, right? Because that will be unlawful. Hindi po tayo pwedeng pumili ng judge natin. Or maybe some people may think, sana papuntahin kay judge ganito dahil baka friendly court, right? But we cannot do that. Lawyers are not allowed to do that. That would be tampering with our judicial system, and we're not allowed to do that. But here in mediation, you can choose your mediator. And there is also speedy disposition of a case. Unlike in judicial courts, where courts may even take 10 to 20 years in resolving a case. I've had that experience, nagmana na po ako ng mga kaso na 20 years old. But ayaw pa ring matapos. The lawyers before me had already expired. Imagine that. So I hope there was a way to settle these disputes until I came across and became familiar with ADR, specifically mediation. And almost all of my cases have been mediated and were terminated. Those 20-year-old cases, 98% of which were terminated because of ADR and mediation. It's cost efficient too. Imagine if there will be a pending case that you will have to bring to court. That may take 20 years. You pay for 20 years attorney's fees, right? For the pleadings, for the appearances, so on and so forth. Not to mention the pain that you go through for all those years. And of course, mediation declogs dockets, because if people can settle their differences, then there is no need anymore to go to courts, except for cases that would really necessitate legal action. Okay, so here I just would want to tell you that our training arm is CORE, or Conflict Resolution Group. As of now, NCM has more or less 79 mediators all over the country, so that if PhilExport has branches or affiliates in the different parts of the country, there will be mediators for you. No? Okay, so what is mediation? Okay, it is a process agreed upon by the parties to settle their differences. The purpose of this consensual process is to reach an amicable settlement. So we would have to have consent of both parties here. So how do you get consent? First and foremost, we encourage you to put a mediation clause in all the contracts that you have. Later on, I will show you an example of that contract, providing the National Center for Mediation jurisdiction to handle your case. No? And of course, we're pushing for that since we are all in PCCI together anyway. We encourage you to bring your disputes to mediation. Okay, there are two main kinds of mediation. We have ad hoc mediation and institutional mediation. In ad hoc, you get to invite a mediator of your choice. Both parties will choose the mediator. The third party neutral is not an institution. So if you think, for instance, that it will be best if you would want Mr. Aure to be your mediator, you can speak to Mr. Aure in his personal capacity. He can be your mediator. Unless, of course, you would want to go directly to the National Center for Mediation, which provides institutional mediation services. What do you expect from mediation? It is a safe environment. What does that mean? In ADR, we practice confidentiality, strict confidentiality. So nobody else will know your case except your mediator. In fact, we are even prevented from, among ourselves, among mediators, to speak about the mediation case that we are handling. Why? We observe strict confidentiality. So here, the public does not get to know what the dispute is all about. No? Say, for instance, there is an exporter and you have a supplier here in the Philippines, and there would be a dispute, and you do not want the business industry or the industry to know about your dispute. You can bring the dispute to mediation. It's hush-hush, meaning that it will be confidential. The handling of such matters will be confidential, and the materials cannot even be subpoenaed, and even your mediator cannot be subpoenaed by the courts. No? So lahat po yan confidential. So these are just some of the things, no, that you can benefit from mediation. So a mediator is a third-party neutral who is control of the mediation process. Let me emphasize that your mediator is an impartial third-party neutral. Wala po tong kikilingan. Okay? We are trained to render services, no, in the most professional way, and observing proper code and ethics, professional code and ethics. Okay, so that is a process. The process is about the parties, and the third-party neutral does not have any personal agenda. Lawyers can join, but they do not take an active role. Why? Your mediators would want to listen to the parties. So the realities of the COVID-19 crisis and reasons why we should opt for mediation. You know that this COVID crisis has really disrupted business. There have been breaches in contractual obligations. There have been non-performance of duties, disruptions in supply chains, massive unemployment, hemorrhaging business industries, especially that of the MSMEs. No, and I cannot just imagine how businesses can have a litany of hardships. Brought about by this COVID crisis. And as you know, when there are crises of these sorts, no, disputes normally arise between management and labor, between contractors and suppliers, so on and so forth. No, since there are losses, unemployment, and grassroots entrepreneurship has been devastated by the COVID crisis. So how do we rise to that challenge? Number one is that we have to change our mindsets. We have to cast there has to be a paradigm shift, no, that we can resolve conflicts not through litigation anymore, and that we can push for mediation and not litigation. Okay, and how do we do this? Now, in the NCM, we have embarked on online mediation so that we observe protocols. If there will be any of you who will be bringing disputes to the National Center for Mediation, we do not conduct, as of now, on-site hearings because we want to observe in the strictest sense our health protocols, no, issued by the no less than the IATF. So we do online mediation, and disputants will have to be familiar with this platform. Currently, we are using Zoom, the Zoom platform, as it is the most convenient way of doing mediation. We also have breakout rooms in Zoom. So benefits of mediation, the gap is bridged, and then we can truly have a gratifying settlement agreement. Of course, it also preserves the relationships because once a case is brought to courts, there is that animosity, no, and the approach to resolving the conflict is adversarial in nature. So magkakagalit na po yan, magkakasamaan na ng loob. Whereas, if you bring your dispute to mediation and your mediator tries to help you have an amicable settlement, then it will be a win-win situation for both parties. And who knows, with that preserved business relationships, the business can go on and even thrive even more. Okay, and harmony, of course, is restored. And may I also add that sometimes in one sitting or even in two sittings, the case is resolved. No, especially if both parties are really eager and zealous to finish and resolve their dispute. Let us remember that in business, the longer the dispute stays, the more losses the business suffers, right? So we have that mediated settlement agreement. What do we do with a mediated settlement agreement? We have it deposited in court. Why? In case one of the party breaches that settlement agreement, you do not have to file a case in court, no, nasisimula na naman ninyo at matatapos what, in 3 or 6 years. And we're just talking about the lower court there. If you bring a case, for instance, in judicial courts, it may take you 3 to 6 years in the lower court, another 3 to 5 years in Court of Appeals, another 3 to 6 years in the Supreme Court. And in rare cases, although this happens, some cases last for 10 to 20 years. But in mediation, so long as the parties really cooperate, you can finish the case in one sitting. At most, probably 3 months, if that will be, if parties are really very difficult. But if not, we can finish this in 2, 3 hearings. This is the mediation clause that I am telling you. You may put this in your contract, and we encourage you really to put this mediation clause in your contract. Any dispute arising from the contract or related thereto shall be referred to the National Center for Mediation. And then just so there will be no confusion, you can put our address there. And I'm sure, second to your residential address, this is the address you know best, right? 3F, third floor, Commerce and Industry Plaza, 1030 Campus Avenue, corner Park Avenue, McKinley Town Center, Taguig City, Philippines, 1600. Okay, so on a final note, we do hope the advocates of ADR and mediation, no, we do hope that in time and one day, the alternative dispute resolution will no longer be called alternative dispute resolution, but appropriate dispute resolution, making ADR and mediation as a mainstream path in resolving disputes. Please note that your National Center for Mediation, a brainchild of PCCI, is just right here with you, and we are ready to assist you. So with that, thank you very much. I will be very pleased to answer your questions.